Is it the most robust, far-reaching gun law in the history of the world? It is not.
That they have taken away our right to have reasonable restrictions. We can have restrictions on speech.
The majority of the American people think having assault weapons is bizarre. It's a crazy idea.
That's not a right of government. That's a right that each of us has as Americans.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
Background of California's gun laws. California has established itself as a state with some of the most rigorous gun control measures in the United States, as corroborated by the 2023 Everytown Gun Law Rankings. This comprehensive assessment places California firearm regulations at the forefront, underscoring their status as the most stringent nationwide. Despite the formidable nature of these regulations, it is noteworthy that pursuits related to firearms, such as hunting and sport shooting, continue to be widely practiced within the state. This popularity is not confined solely to adults, as even minors actively engaged in these activities, including those who have not yet reached the age of majority. Possession of firearms by minors. In California, there exists a legal framework that allows minors to responsibly engage with firearms under specific circumstances. State law, as delineated in the California Penal Code sections 29615 and 29610, expressly grants minors the privilege to possess and utilize firearms for activities that are both lawful and recreational. These include pursuits like competitive shooting, hunting. It's imperative to note, however, that this authorization is contingent upon the minor obtaining the consent or supervision of a parent or legal guardian. This provision ensures that the minor's interaction with firearms is conducted in a controlled and supervised manner, prioritizing safety and compliance with legal requirements. Furthermore, California goes a step further in fostering responsible firearm use among minors. The state proactively encourages their participation in these activities by instituting a system of discounted license fees for what are referred to as junior hunters.
Some legislator down there has come up with an absolute insane idea of a law.
Is it the most robust, far-reaching gun law in the history of the world? It is not.
This initiative is tailored for individuals below the age of 16, demonstrated a concerted effort to both facilitate and incentivize the engagement of young enthusiasts in lawful firearm-related pursuits. This approach seeks to strike a balance between regulatory measures and a genuine appreciation for the cultural and recreational significance that firearm holds for many Californians, even those who have not yet attained adulthood. Concerns about youth interests in firearms. Amidst the backdrop of heightened concerns surrounding gun violence, the California legislature has taken a proactive stance regarding the involvement of young individuals with firearms. In the eyes of the legislature, there exists a genuine worry that the proliferation of firearms among minors could potentially pose a significant threat to the safety and security of both residents and visitors within the state. This concern arises from the recognition that, when not appropriately managed and regulated, the presence of firearms in the hands of young individuals could lead to unintended consequences and heightened risks. In essence, the legislature's intent is to strike a balance between preserving the rights of individuals to engage in lawful firearm activities and mitigating the potential hazards that may arise when such privileges extend to minors. By doing so, they aim to foster an environment where firearms are accessible and utilized responsibly, while safeguarding the well-being of the broader community. Regulation of the firearm industry. In response to concerns surrounding youth involvement with firearms, the California legislature opted for a nuanced approach rather than repealing existing firearm possession laws for minors. Recognizing the potential opposition such a move might elicit from lawful firearm users, the legislature turned its attention to the firearm industry's advertising practices as an alternative means of addressing their apprehensions.
This time about a law that restricted certain types of advertisement as it relates to the firearm industry.
That they have taken away our right to have reasonable restrictions. We can have restrictions on speech.
But what this is an appeal of what started as Assembly Bill 2571.
The resulting legislative outcome took the form of Assembly Bill AB 2571, a comprehensive piece of legislation that has since been codified as 22949.80 within the California Business and Professions Code. AB 2571 adopts a strategic focus. It concentrates on exerting control over how the firearm industry conducts its advertising endeavors, particularly with regard to products that could be alluring to minors. This legislative maneuver illustrates a thoughtful and pragmatic attempt by the California legislature to navigate a complex and sensitive issue by directing their attention to advertising practices within the firearm industry. They aim to address concerns about youth interests in firearms without significantly altering existing possession laws, thereby attempting to harmonize the rights of lawful firearm users with the overarching objective of safeguarding public safety. Provisions of AB 2571. Assembly Bill 2571, now enshrined as 22949.80 within the California Business and Professions Code, introduces a set of specific provisions aimed at regulating how the firearm industry conducts its advertising practices. This statute lays down clear directives that firearm industry members must adhere to in order to ensure their advertising efforts align with the intended objectives of the legislature.
The majority of the American people think having assault weapons is bizarre. It's a crazy idea.
It's going to save lives, and it was going to save lives by restricting how companies would be able to market their products.
It is essential to underscore that the regulation outlined in AB 2571 is tailored specifically to marketing or advertising endeavors. However, the law also includes several vital exceptions. It recognizes the importance of initiatives related to firearm safety programs, shooting competitions, hunting activities, and membership in organizations associated with firearms. These carve-outs demonstrate a nuanced approach to regulation, acknowledging that certain contexts merit distinct considerations when it comes to the promotion and dissemination of information related to firearms. Criteria for determining attractiveness to minors. For advertisements falling within the purview of this regulation, 22949.80 meticulously outlines a comprehensive assessment process. This involves applying a totality of the circumstances test to ascertain whether the market content is, in fact, perceived as attractive to minors. Additionally, consideration extends to the presentation of firearm-related products, taking into account elements such as size, color, and design that may inherently resonate with younger individuals. Furthermore, the use of images or depictions of minors in advertising materials showcasing the utilization of firearm-related products forms a critical component of this evaluation. By incorporating this multifaceted evaluation process, the legislation aims to create a robust framework for assessing the potential impact of advertising efforts on minors. It underscores the legislature's commitment to striking a balance between responsible firearm use and safeguarding the welfare of young individuals from potentially inappropriate or alluring advertising content. This approach is rooted in a comprehensive understanding of the nuanced factors that influence perception and preferences among the youth demographic. Constitutional challenge. The plaintiffs have brought forth 4 key claims against the California gun law, arguing that it infringes upon their constitutional rights. Initially, they contended that the law's definition of firearm industry member was overly broad, potentially encompassing a wide array of entities, including those advocating for gun rights and organizations promoting shooting sports and safety training. Furthermore, the plaintiffs argued that the law not only restricted advertising to minors for firearm purchases, but also curtailed various forms of speeches, including what they termed as honest commercial speech and a broader category of pure speech. This included communications from publications encouraging youth involvement in shooting sports, educational initiatives by gun rights organizations, and promotional efforts by firearm industry members. Throughout their case, the plaintiffs emphasized that California lawmakers displayed a clear bias against the firearm industry during public discussions about the law.
Inside the state of California, the law that's being challenged here specifically read,
"An assault weapon's only purpose is to kill people efficiently."
They contend that even if the law is considered a regulation on commercial speech, it cannot withstand the less rigorous scrutiny applied under the Central Hudson Standard, Finally, they argue that the law infringes on their political and ideological free speech rights, as well as their right to associate and their right to equal protection under the law. In their supplemental filings after the law underwent amendments, the plaintiffs maintained that the changes were merely superficial and that the newly added exceptions category only further highlighted the law's alleged unconstitutional censorship. These arguments will be contested by the defendant in the subsequent proceedings. Judicial notice granted. Plaintiffs' formal request to the court for judicial notice of specific documents pertaining to Assembly Bill 2571 and its legislative history. Judicial notice is a legal process that allows a court to acknowledge and consider certain facts without requiring formal proof, either because they are generally known or easily verifiable from reliable sources. This request is made in accordance with Federal Rule of Evidence 201, which governs the admissibility of such evidence. The plaintiffs have identified 10 distinct documents for judicial notice, each of which plays a significant role in illuminating the legislative process and intent behind Assembly Bill 2571. These documents encompass a range of materials, including various versions and analysis of the bill, as well as related documents like committee reports and floor analysis. By presenting these materials for consideration, the plaintiffs seek to provide a court with a comprehensive understanding of the legislative context surrounding Assembly Bill 2571. A key legal principle that legislative history is a valid and appropriate subject for judicial notice. Consequently, there is a mutual understanding between the parties involved, suggesting that the documents in question hold significance for both sides of the legal proceedings. In light of the circumstances, the court ultimately agrees with the plaintiff's request for judicial notice. The court explicitly states that it finds their request appropriate and grants it. This means that the court formally acknowledges and accepts the submitted documents as admissible evidence. As a result, these documents will be considered in the proceedings, enabling them to inform the court's interpretation of the legal issue surrounding Assembly Bill 2571 and its constitutionality. Legal standard for preliminary injunctions. A preliminary injunction is considered an extraordinary and powerful remedy, and its issuance requires a compelling demonstration by the movement. This principle is emphasized in the case of Lopez v. Brewer, which underscores that such relief should only be granted when the movement makes a clear and persuasive case. The Supreme Court's ruling in Winner v. Natural Resources Defense Council further refines the standard, specifying 4 key elements the plaintiff must establish. 1. A likelihood of success on the merits. 2. A likelihood of experiencing irreparable harm without the injunction. 3. A balance of equities in favor of the plaintiff. And 4. An injunction being in the public interest. Notably, the likelihood of success on the merits holds particular significance in this assessment, as affirmed in California v. Azar. Additionally, it is essential to note that a preliminary injunction is generally disfavored.
When a court says that injunctive relief is proper, not only does it mean that the plaintiff in that case is suffering irreparable harm.
They are obsessed with attacking law-abiding Americans' Second Amendment liberties,
when it essentially mirrors the final relief sought in the case. This is established in Progressive Democrats for Social Justice v. Bonta, highlighting the customary function of a preliminary injunction in preserving the status quo during legal proceedings rather than conclusively settling the case. Constitutional avoidance of facial challenges. Facial challenges to a statute require the plaintiff to demonstrate that there are no conceivable circumstances under which the statute would be valid, or that it lacks any clearly legitimate applications. This legal principle is articulated in United States v. Stevens. Facial challenges are met with caution, as they often entail a risk of prematurely interpreting statutes based on insufficient factual records. Moreover, when constitutional issues arise, courts are guided by the principle of constitutional avoidance, which advises against addressing constitutional questions if they can reasonably be avoided. This principle is derived from the cause of Ashwander v. Tennessee Valley Auth, and holds that if a reasonable interpretation of a statute would raise serious constitutional concerns, the court should opt for an interpretation that avoids such issues, as long as it aligns with legislative intent. Principles of statutory interpretation. When the statutory language is unequivocal, it must be enforced as written. However, in cases where the meaning and ambiguity of specific terms becomes apparent only in context, courts must examine the language within the broader statutory framework. This principle, exemplified in King v. Burwell, underscores the importance of considering the overall legislative scheme when interpreting statutory language. In the Ninth Circuit, the process involves an initial analysis of the plain language, followed by an assessment of the statute's legislative history if the language remains unclear. This approach, as articulated in Northwest Forest Res Council v. Glickman, highlights the dual consideration of both the statute's explicit language and its broader legislative intent. Landmark ruling. In a significant legal victory for Second Amendment advocates, a Californian gun law has been declared unconstitutional and subsequently canceled by a court. The law in question, initially introduced as Assembly Bill 2571 and later incorporated into the California Business Code as 22949.80, sought to control how companies within the firearm industry could market their products. Specifically, it prohibited firearm industry members from advertising, marketing, or arranging the placement of advertisements for firearm-related products in a manner that was deemed attractive to minors. The crux of the legal challenge against this law was its potential infringement on the Second Amendment rights of Californians.
They are coming for your guns. They're listing them out in this extensive legislation.
Prohibitions such as this are permissible.
Critics argued that the law's language, particularly the ambiguous phrase "attractive to minors," made it susceptible to broad and arbitrary enforcement. Additionally, it raised concerns about curtailing the free speech rights of firearm-related businesses by limiting their ability to market their products. The court, in its ruling, found that the challenged law violated the Second Amendment rights of Californians by imposing overly restrictive regulations on the marketing and advertising of firearms. This court decision has several important implications. Second Amendment protection. It reaffirms the importance of protecting the Second Amendment rights of individuals, even in states known for strict gun control measures. Legal precedent. This case may serve as a legal precedent for future challenges to gun control laws in California and other states, emphasizing the need for laws to be clear, specific, and constitutionally sound. In conclusion, the cancellation of the California gun law to its unconstitutional nature is a significant legal development that upholds Second Amendment rights and reinforces the importance of clear and constitutionally compliant firearm regulations. California gun law invalidated. The legal matter at hand pertains to an appeal stemming from the introduction of Assembly Bill 2571, which was subsequently incorporated into the California Business Code as Section 22949.80. A significant development occurred when Junior Sports Magazine initially challenged the law and sought an immediate injunction. Although the district court initially denied the request, a three-judge panel in the Ninth Circuit subsequently reversed this decision. This reversal marked a positive turn for Junior Sports Magazine, indicating not only that they were suffering irreparable harm, but also that they were likely to succeed in their argument against the law's constitutionality. It's crucial to note that this legal challenge primarily centers on the First and 14th Amendments, framing it as a First Amendment issue related to the restriction of free commercial speech. The court underscored that the case did not revolve around whether children could legally purchase firearms, as California law expressly prohibits this, nor did it concern whether minors could use firearms under proper adult supervision, which is allowed for lawful purposes like hunting and target practice. Instead, the core of the matter was whether California could prohibit truthful advertisements about firearms used legally by both adults and minors solely on the basis that the ad might appear attractive to minors. The court addressed that states could only ban truthful and lawful advertising if it significantly and directly advanced a substantial government interest, and only to the extent necessary. In this case, California's law did not meet this rigorous standard. The court astutely noted that while California undeniably had a substantial interest in reducing gun violence and unlawful firearm use among minors, this law did not effectively contribute to those goals. Consequently, the court concluded that, The law was not narrowly tailored to advance the stated public interests, highlighting the necessity for such restrictions to be carefully crafted and demonstrably effective in order to pass constitutional muster. This ruling represents a significant development in the ongoing debate surrounding firearm regulations and constitutional rights in California. California's firearm advertising law struck down. In a groundbreaking legal development, a California law designed to regulate firearm advertising has been declared unconstitutional by the court, marking a pivotal victory for the First Amendment rights. This landmark decision has far-reaching implications for the intersection of free speech, Second Amendment rights, and public safety concerns within the state. This court's decision underscores a fundamental principle: there is no exception to inalienable rights, even in the pursuit of public safety. The ruling challenges the narrative often presented in arguments advocating for stricter gun control laws, asserting that good intentions and wishful thinking are insufficient grounds for infringing upon constitutional rights. This landmark decision sets a significant precedent, emphasizing the importance of legislation being clear, specific, and constitutionally sound. It reaffirms the principle that the government must provide substantial evidence to justify restrictions on free speech, especially in matters of public interest and constitutional rights. The court's willingness to reverse the district court's denial of a preliminary injunction signals a pivotal step towards upholding First Amendment rights in the context of firearm advertising in California.
This is a First Amendment challenge. This is a challenge on restricting otherwise free commercial speech.
That's not a right of government. That's a right that each of us has as Americans.
The court's ruling represents a substantial victory for proponents of free speech and Second Amendment rights. It challenges the balance between public safety concerns and fundamental constitutional rights, underlining the need for legislation to be carefully crafted and constitutionally justifiable. This landmark decision will undoubtedly influence future legal debates surrounding firearm advertising and may prompt a re-evaluation of similar regulations across the United States. Legal setback for California. In this recent legal development, the case concerning California's controversial firearm advertising law, codified as California Business Code 2294980, is slated for remand. This means the case will be sent back to the district court with clear instructions to accurately interpret and allow the law. This remand is pivotal as it signifies an opportunity for the district court to re-evaluate the case in light of the Ninth Circuit decision. The Ninth Circuit decision to remand the case is a significant setback for Governor Gavin Newsom and Attorney General Rob Bonta, who have been staunch advocates for stringent gun control measures in California. This marks another instance where the Ninth Circuit has struck down a piece of legislation related to civilian disarmament in the state.
That's the Ninth Circuit, not the most Second Amendment friendly court in America. Well, guess what? They've done it again.
Their legal analysis is poor, their conclusions are misguided, their outcomes are dangerous.
It was then appealed to a 3-judge panel in the Ninth Circuit who has reversed that decision, okay?
The case, titled Junior Sports Magazine v. Bonta, represents a high-profile legal battle over the intersection of First and Second Amendment rights. The specific law in question, California Business Code 2294980, sought to regulate how companies within the firearm industry could market their products. It prohibited firearm industry members from advertising, marketing, or arranging the placement of advertisements for firearm-related products in a manner deemed attractive to minors. The legal challenge primarily focused on potential infringements on First Amendment rights, particularly the ambiguity surrounding the term attractive to minors. The Ninth Circuit decision to remand the case carries significant implications. It acknowledges the need for a careful and accurate application of the law, ensuring that constitutional rights are upheld. The court's ruling reflects a commitment to preserving both free speech and Second Amendment rights, even in the face of efforts to implement stricter gun control measures. This decision is consistent with a broader trend of judicial scrutiny towards California's firearm regulations. Ultimately, this legal development serves as a reminder of the responsibility that comes with being a lawful and responsible gun owner. It highlights the importance of understanding the intricacies of gun laws and how they apply in various situations, As this case moves forward, it will undoubtedly continue to be closely watched by advocates on both sides of the gun control debate, as it addresses crucial issues regarding constitutional rights and public safety concerns. That's all for this video, folks. See you next time.